Good morning, madam. My name is Bong Sze Yin and my matrix number is 05D8022F2014 and my group member is Danelisa Eleanor 05D8022F2016 and the Lim Hui Fang 05D8022F2018. Today we are diving into the legal aspect of selling a business, specifically focusing on termination of agency and the principle of nemo dat quod non-habet rule within the Malaysian legal framework.
Welcome, potential buyers and fellow entrepreneurs. We're the proud owners of Golden Spoon, a beloved street food business in Kuching, Malaysia. As we embark on the journey of selling our successful venture, we recognize the importance of understanding the legal intricacies involved in such a transaction. In this video, we delve into two critical aspects of Malaysian law pertinent to selling a business: the termination of agency and the principle of nemo dat quod non-habet rule. Let's explore this concept and their implications together.
Agency is a legal relationship where one party known as the principal authorizes another party known as the agent to act on their behalf in business transaction. In the context of selling Golden Spoon during Commerce Week, agency would be relevant as it allows the principal, the seller of Golden Spoon, to appoint agents such as employees or representatives to conduct sales, negotiate contracts, or handle other business matters on their behalf. This delegation of authority streamlines operations and expands the reach of the business, enabling the principal to focus on other aspects of running the enterprise. Three ways in which an agency relationship can be terminated. Termination by agreement. This is when the boss, principal, and the helper agent decide to stop working together. Maybe the boss want to cross the sort or change teams out, or maybe the helper want to move on. They talk it up and agree to end their partnership. Termination by operation of law. Sometimes things ends not because both parties agree, but because of legal stuff. For example, if either the boss or the helper cannot continue due to things like getting sick, going bankrupt, or given passing away, the partnership ends automatically. Termination by breach of agreement. This is like breaking the rules if either the boss or the helper does not do what they are supposed to do, does something they are not allowed to. It can lead to ending their partnership. For example, if the helper does something wrong or the boss does not pay as promised, it can be a reason to call it quits.
Based on my selling experience during Commerce Week, there got three methods of terminations. The first one is terminations by agreement. Both parties desire and agree that the agency shall terminated. The agency is terminated. The second one is terminations by agents renunciations. An agent may terminate when the agent surrender his or her authorities and by doing so end the mandate given to him as agent. The third one is terminations by performance. According to the Sections 154 Contract Act, the contract of agency is ended when the agent has performed the contract. The illustration is me as a seller or agent. Danelisa and Bong is the customer. Danelisa and Bong have made a contract with me, which is the contract is about they want to order some food for a birthday party. After completing the order, we agree to terminate the contract. Principle of nemo dat quod non habet rules. Nemo dat quod non habet is Latin word for no one give what they do not have. Is a fundamental principles in property law. It's dictated that a person cannot transfer a better title to property than what they themselves possess. In the context of selling golden spoon, this rule ensures that buyers receive valid title to the product they purchase, protecting them from author- authorized or fraudulent sales.
Number one is sale by a mercantile agent. When goods are sold by a mercantile agent who is in possession of the goods with the consent of the owner, the buyer acquires a good title to the goods as long as they act in good faith and without notice of the seller's lack of authority. If takoyaki were being sold by a mercantile agent of the company that owns the brand, the buyer would obtain a good title under the first exception. Number two is sale by one of joint owners. If one of the joint owners of goods have the sole possession of them by consent of the co-owners, the sale of the goods to a third party who buys them in good faith without notice of the joint ownership will give the buyer a good title. If takoyaki were owned jointly and one of the owners sold the goods without the other's knowledge but with the buyer acting in good faith, the sale would still be valid under the second exception. Number three is sell under a voidable contract. If goods are sold by a seller who is in possession under a voidable contract and the contract has not been rescinded at the time of sale, the buyer acquires a good title to the goods, provided they buy them in good faith and without notice of the seller's defective title. If the contract under which takoyaki were sold was voidable but not yet rescinded, and the buyer was unaware of this fact, they would still receive a good title under the third exception. Number one is sale by a mercantile agent. Scenario where takoyaki is a popular snack brand and its distribution is handled by various mercantile agents. Bong Sze Yin is one of the agents without explicit permission sells a batch of takoyaki to a local supermarket. For example, the supermarket, unaware of the agent's lack of authority, purchases the snacks in good faith. Later, it's discovered that Bong Sze Yin was not authorized to sell that particular batch. However, under this exception, the supermarket still holds a good title to the takoyaki because they acted in good faith and the agent had possession of the goods with implied consent. Number two is sale by one of joint. Scenario where Danelisa and Hui Fang jointly own a stock of takoyaki. Hui Fang decides to sell the entire stock to a distributor without informing Danelisa. Example: the 83bis buys the stock in good faith without knowledge of the joint ownership. When Danelisa objects to the sale, the law protects the distributor's title because the selling partner had the consent of the co-owner to possess the goods, and the distributor was unaware of the joint ownership. Number three is sell under a voidable contract. Scenario where a retailer acquires a large quantity of takoyaki under a contract that is later found to be voidable due to the wholesaler misrepresentation. For example, before the contract is rescinded, the retailer sells some of the takoyaki to a chain of convenience stores. The stores, having no knowledge of the voidable nature of the retailer's contract, obtain a good title to the goods. Even if the original contract is later rescinded, the convenience store's title to the takoyaki remains valid.
As we conclude, we hope this video has provided you with valuable insight into the legal aspect of selling a business in Malaysia, particularly within the context of golden spoon. Understanding the terminations of agency and the nemo dat quod non habet rule is paramount for both buyer and seller to navigate this process smoothly and effectively. As we bid farewell to Golden Spoon, we are excited for the new opportunities that lie ahead and trust that the legal knowledge shared here will serve us all well in our future endeavors endeavors. Thank you for joining us on this journey.